say this is absolutely not try the other misleading. But that's not the point you're watching. The proceedings of today are seeking worship, correct people on record. You have a prayer to make. You have received instructions. Worship. Ask you. Worship. Says you at the following grounds. One, you worship. Important instructions. Raise a complaint against you. The Judicial Service Commission. Administration of justice. Incompetence. Abuse. Worship. Copy of the complaint which is already filed before the Judicial Service Commission. Yeah. For record purposes. Worship. Substantiate. The accused, the respondents in this matter have gotten reasonable fear and apprehension that you will not have the requisite confidence to adjudicate a matter of this nature and to dispense justice, considering the existence and the proceedings that have happened before. So, the propriety of this proceeding being manifestly unconstitutional. Last time the matter here indicated that they had finalized all the investigations they wanted to conduct and proceeded with the control proceedings, Your Worship. Section 168 of the Magistrates Court Act. This honorable court is to have jurisdiction over a matter that is triable by High Court upon conclusion of the pre-trial process. Once the state has summed up its case, that the committal papers, trial is forwarded to the High Court for purposes of trial. This honorable court is being exhausted its jurisdiction and has no residue powers whatsoever under any interlocutor application. This court is the first of its kind. If I may bring myself into the picture of the proceedings, my 28-year practice, I have never witnessed such kind of proceedings. I'm sure many lawyers will attest to this fact, including judicial officers, that after the top proceedings are done, they can be any other application to get a magistrate whose jurisdiction is restricted to trial. That basis that the respondent is here. Convinced that your worship have demonstrated gross incompetence in managing the matter. This matter, grave offense that has implications as far as the other is concerned, which carries a death sentence. The matter that carries a death sentence. The other ground, your worship, is the failure by this honorable court to comply with the dictates of the Constitution under Article 23, Section 76. Of the Magistrates Court Act. Provisions were assented before you, your worship, and the approaching is mandatory. Not 188 before for the job, and mandatory. And this honorable court cannot conduct any other business apart from addressing this. And the practice guideline is what now want to do in Washington. Particularly guideline number 10.2, paragraph 2, which requires you to decline to plan mandatory training before they might file with high court. Washington, you do not pronounce this. Later, you have to speak as more than 100. You have never ruled in that. You have never meditated the rule. In which case, you will proceed to determine whether you are entitled to mandatory pay or not. If you find that actually you lack the requisite jurisdiction because of this guideline. Yes, you fall back on that guideline 10 and forward it by your high court. That was never done. That is also considered as an act of person. Finally, worship the applicants relying on the authorities of Attorney General of the Republic of Kenya, the applicant versus Professor Anyang, an East African case. East African Court of Justice at Arusha, application number 5, 2007. Lordships had this to say that for the purposes of the application for accused, do not find it necessary to delve into the controversy on the test that Dr. Priya addressed us on at length. We think that the objective test of reasonable apprehension of bias is good. Reasonable apprehension of bias is good law. It will not apply its mind to the case impartially. Needless to say, the litigant who seeks disqualification of the judge comes to court because of his own perception that there is appearance of bias on the part of the judge. The court, however, has envisaged what would be the perception of a member of the public who is not only reasonable but also fair-minded and informed about the circumstances of the case, what it would be. I make my submissions on this. I would also like to quote the authority of the Crystal Betting and Game Licensing Committee, an expert application. This is for me, this is an English decision of the Supreme Court. The principle recited the House of Lords is that the policy of the common law is to protect litigants who can discharge the lesser burden of showing the real danger of bias without requiring them to show that such bias actually exists. The point here, the worship application for that is on the perception of the applicants, of the accused persons, whether indeed this court will dispense justice or not. And in this particular case, the worship on the basis of these authorities and the evidence before you, the accused persons are convinced beyond all shades of doubt. Actually, have been manifestly demonstrated bias against them. And also, knowing now, consider without exactly knowing what their fate is as far as mandatory paying is concerned. They don't know. After working over 180 days without commitment, they don't know. So we do pray that your worship will do this, please yourself, and terminate these proceedings.
Much obliged, Your Worship. Your Worship, I wish to join issue with the senior counsel that's to follow.
I take that for the record. I am free now.
Worship, in further submission or application for
proceeding under Guideline 7, the constitutional recusal of judicial officers practice directions of 2019. The constitutional recusal of judicial officers practice directions of 2019, wherein Section 7 states, Guideline 7 states that a party proceedings may apply to a court for a judicial officer to recuse him or herself under the following circumstances, and we are interested more in Guideline E, that where a judicial officer makes inappropriate comments or exhibits unacceptable conduct in the course of the hearing, and in F, where a judicial officer exhibits actual, implied, or apparent bias, then they are bound to recuse themselves. Your Worship, the inappropriate comments that our clients think that should be the basis of your recusal are when you stated that A1 and A2 waived their right to legal representation by telling their lawyers to do what is more urgent at that time, and it was your viewing of the report and the report shows that you stated that they waived their right to legal representation. Your Worship, we bring it to your attention that under Article 23 and Article 28, 3E, a right to legal representation in a capital offense can neither be derogated or waived by an accusing person. And it is the reason why that specific article provides that in circumstances where private legal representation is not available, the state must avail or provide a lawyer to an accused person where the offense can lead to death. And I beg to read the specific clause in verbatim. That in the case of any offense which carries a sentence of death or imprisonment for life, the accused person shall be entitled to legal representation at the expense of the state. That not at any one point can an accused person waive his right to legal representation in a capital offense nature that can arise to him being convicted and sent to death, that in any instance where he or she cannot afford, no private lawyers are not present, the state shall provide a lawyer to make sure that the right to legal representation is upheld at all times. Your Worship, that position was stated further by the Constitutional Court in the decision of Grace Peter and Fred Marion Maisho versus Attorney General